Good morning, Ms. Benson.
Good morning, how are
And
you?
you charged with driving while intoxicated, you're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
On April 21st, 2025, in Harris County, Texas, a law enforcement officer was dispatched in reference to a wrong-way driver and initiated a traffic stop on the vehicle described by the 911 caller. The law enforcement officer made contact with the defendant and the defendant handed the law enforcement officer an unopened alcoholic beverage. The law enforcement officer noticed the strong odor of an alcoholic beverage coming from the vehicle, and the defendant appeared unstable and fell against her car. The defendant stated she spilled a whole can of beer on herself earlier. The defendant's vehicle appeared to have fresh damage consistent with hitting a curb. Standardized field sobriety tests were conducted, where the officer observed 6 out of 6 clues in the HGN, 3 out of 8 on the walk and turn, and 0 out of 4 on the one-leg stand. An inventory search revealed 3 open and empty beer cans in the back seat floorboard and other unopened alcoholic beverages.
Whoa, look at that back reading. Over 214 is well above the legal limit in Texas. And those field sobriety tests? HGN 6 out of 6. Walk and turn 3 out of 8. This is textbook impairment. But here's the kicker. Sometimes the context matters. And that unopened drink could complicate the story. What would you do if you were the judge right now?
Defendant considered to breath and blew .143 and .145.
What did you say the stop was for?
The stop was for, there was a 911 call that stated there was a vehicle driving the wrong way and described the vehicle. The officer found the vehicle.
Driving the wrong way?
I'm not sure. When the officer found the vehicle, it was not driving the wrong way, but it matched the description given by the 911.
Right. Anyone can call and say anything. Did he view any kind of traffic infraction? I could literally call and say, hey, man, state's driving nuts. Go get him. Right? I mean,
There's
Yeah.
no other
Okay.
traffic infraction.
Benson, I'm going to find that there's no probable cause to go forward with your case. There's enough death and destruction on our streets. Now, play it safe. The last thing you need is to end up in a 6x9 because if you get into an accident, maim, kill someone, especially with alcohol in the car. Do you understand? Play it safe. Don't make any boneheaded moves. Please. Thank you, Your Honor. Good morning.
I have an arraignment for Ms. Rice.
Do you mind bringing her up?
I do believe PC has not been found or.
Okay. Good morning, Ms. Rice. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Thank you, Your Honor. On April 22nd, 2025, in Harris County, Texas, law enforcement officers were dispatched to a crash call and found a vehicle inoperable due to a collision and blocking traffic. Law enforcement officer spoke to a wheel witness who stated he observed the defendant in the driver's seat of the vehicle with the engine on and advised the defendant to turn the vehicle off and exit the scene. The law enforcement officer made contact with the defendant who was sitting in the driver's seat of the vehicle and observed slurred speech, moderate odor of alcoholic beverage, and glossy eyes. The defendant admitted to consuming 1 alcoholic beverage. SFST standard field sobriety tests were conducted. A 6 out of 6 on the HGN was reported, a 7 out of 8 on the walk and turn, a 2 out of 4 on the one-leg stand. The defendant refused to provide a specimen. A blood warrant was obtained and executed.
If I may, Your Honor, what the officers completely failed to leave out of their report is that the car was registered to the other person that was present. The other person had the keys on them. The other person admitted to driving. At the time of the accident, I'm not sure why they switched seats. I don't know. I do know the wheel witness came after the accident had already occurred. They had been waiting on a tow. If the officer would have done any due diligence in his research or questioning, the other person they may have been intoxicated. I'm not sure. He didn't even follow up with them. They openly admitted, this is my car. I'm the one driving. The officer made no attempts to remedy that situation or even mention that in his report.
Have you had any of that?
Your Honor, I would just say that, I mean, based on what we have in the DIMS, we witness put the defendant in the driver's seat of the car.
After the car was already inoperable. He didn't see her. He didn't see the accident.
Your Honor, I would say for probable cause purposes, we have a wheel witness that says they saw the defendant behind the driver's seat.
Of an inoperable car.
And a law
I mean,
enforcement officer saw.
at the scene of the accident, right? I mean, if you have some kind of other evidence to show, I have to give them time also, you know?
understand probable
I mean, this is just,
low burden, yes.
probable cause is a very low burden, right? So this doesn't,
Probable cause has been found. But hold on, did you catch the witness timeline? The defendant wasn't even driving at the time, according to the other person. This is why courtroom dramas are so tricky. If you were the defense attorney, what angle would you use to poke holes in this case?
mean that you're guilty. I mean, if that's in fact true, that's why we have trials, right? There's always two sides to the story. I wasn't there. You were there. You know what happened. I don't know. So that's something that you bring out in trial and, you know, perhaps even before, if you show it to them and and it's in fact true, then, you know, they'll kick it. But I'm going to find that there's probable cause to go forward with the case for now. Ms. Rice, any prior DWIs?
No, Your Honor.
License?
Check on the license right
Please.
second.
Like I said, I'm finding probable cause. I'm warning you not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke.
So there you have it. Bond conditions, strict monitoring, and a big warning from the judge. This is a classic example of the system balancing caution with fairness. Remember, in court, every detail matters. The timeline, witness statements, even the drinks in the car. What do you think will happen next in this case?
Your bond puts you in jail. You understand. You're not allowed to drive unless you have a valid Texas driver license and liability insurance as well, okay? That is a part of your bond condition as well. If we find that you're driving, you don't have insurance or any other violation, you will go to jail. No more PR bonds. Do you understand?
Yes, sir.
Now, you've got great lawyers. They'll take care of you because you have them. I will waive your appearance. You don't have to waste your time coming to court. But stay in touch with them and they'll tell you if and when you have to come back to court.
Yes, sir.
Judge, I'm sorry, I'm running this license. It's not loading right now. Okay, here it comes. Judge, the license is eligible.
Okay, great. So what we'll do for now is we'll have you go to Victoria Sign and Reset. You'll get with Roxanne for your bond conditions and after that, you're free to go.
Thank you, Judge.